Facebook and Twitter. All right, so that is our question of the day. Let's move on to this new survey findings showing that local data privacy laws positively affect business, helping organizations to mitigate risks, improve trust and protect their customers' data better. We speak now to Advocate Pansy Tlakula, who's Chairperson of the Information Regulator of South Africa, about the Protection of Personal Information Act, which comes into effect on the 1st of July. That's tomorrow. Very good evening to you, and thank you so much for speaking to us, Advocate Tlakula. So, we're saying it's good news. I'm sure a lot of viewers, or at least some of them, can attest to the fact that they've already started receiving emails, correspondence about the law to this effect. What exactly is it that businesses or those who have our personal information are safeguarding at this point in ensuring that we understand the reason why they have our personal information?
Good evening, SABC, to you and your viewers. The Protection of Personal Information Act prescribes the conditions for lawful processing of personal information. So anyone who processes personal information who falls within the ambit of the Act has to ensure that they comply with those conditions. And those conditions include the following: that anyone who processes personal information of another must get the consent of the owner of the personal information. They must use the personal information only for the purpose for which they collected it. They must collect minimal personal information. For instance, if you apply for a job, there are certain questions that you cannot be asked, like your sexual orientation, for instance. That will be over-processing. So only minimal information has to be collected. And if the information is going to be used for a purpose other than for which it was originally collected, then the owner of the information must consent. And most importantly, whoever collects personal information and processes it must ensure that they maintain the integrity and the confidentiality of that information, and they must keep it only for the period for which they need it. So I've given you, in a nutshell, some of the conditions that have to be complied with.
So you're empowered under Section 40, subsection 1 of POPI, so to speak, to monitor and enforce compliance. But how do we as individuals know, as you said, they are supposed to keep information for a certain period of time, but how you do the oversight for us, but how do we become proactive to ensure that that is done?
Well, if you think that someone has your personal information without your consent, you can lodge a complaint to the information regulator, or you can actually even put a request to the company that holds your information to confirm that they are holding your personal information, what personal information are they holding, and you can actually even request them to delete that personal information. But over and above that, you can lodge a complaint with the regulator. The significance of tomorrow being the 1st of July is that the enforcement powers of the regulator are coming into effect. Before the 1st of July, we could not provide remedies to those whose personal information was processed not according to the provisions of the law.
So you will have an enforcement committee that will help you to do this, and will have powers to issue notices against responsible parties in cases of non-compliance. Are there particular forms of non-compliance that are not listed in the legislation, or that you feel that needs to be spelled out to us?
Well, because the information regulator is a creature of statutes, our powers are derived from the Act. So we have to comply with the provisions of the Act and to ensure that we regulate the compliance with the Act. We can't do anything that is outside the powers of anything outside the ambit of the Protection of Personal Information Act.
So just how punitive would non-compliance be? As in, how much would a fine be, go as far as millions of rands in penalties? Could it result in imprisonment?
Up to 10 million rands for that's an administrative fine. So non-compliance can attract a fine of up to 10 million rands, and non-compliance with certain provisions of the Act can attract imprisonment up to 10 years. So if a responsible party has been found not to have complied with the provisions of the Act, an enforcement notice will be issued directing them to do certain things or to stop processing in a certain manner. Failure to comply with that enforcement notice is the one that attracts sanctions, because failure to do that can attract an administrative fine of 10 years or administrative fine of 10 million, I beg your pardon, and 10 years imprisonment.
Okay.
And or,
So there was Section 58.2 in relation to Section 57, the application for prior authorization. Has this been finalized? Is it part of what comes into effect tomorrow?
No, we actually decided to postpone the commencement of Section 58.2 to the 1st of February 2022. We have to emphasize that that is the only provision whose coming into effect has been postponed, because there seemed to be a lot of confusion out there that the whole Act or the commencement of the whole Act has been postponed. The Act came into operation last year. The only thing that was suspended until tomorrow was the enforcement powers of the information regulator. So only Section 58.2 has been postponed, and that section deals with responsible parties that process certain types of personal information that require them to apply for prior authorization from the regulator. If Section 58.2 had come or was to come into effect tomorrow, it would have meant that all those people who are processing personal information who require prior authorization would have to stop processing that personal information until we have granted them that prior authorization. These are people like credit bureaus, for instance. So because just of the volume of applications for prior authorization that we received, we decided to postpone the coming into effect of that section to the 1st of February 2022.
No, thank you so much for that clarification and your insights. Advocate Pansy Tlakula, who's Chairperson, Information Regulator, South African, she says what actually is happening tomorrow then is the affecting of her office overseeing this legislation, which she says came into effect last year. We're going to take a quick